Hello, NCIA members and supporters, and welcome to another edition of NCIA's Industry Essentials Educational Webinar Series. NCIA's Industry Essentials are our new weekly educational series featuring a variety of programs allowing us to provide you timely, engaging, and essential education when you need it most. My name is Brian Gilbert, the events manager here at NCIA, and I'm very pleased to introduce another amazing educational opportunity for you all this morning. If you're just joining us, please note that we will be conducting Q&A at the conclusion of the presentation. So if you have any questions for the panelists, please don't hesitate to pose them. You can do so by either using the Q&A feature available along the bottom toolbar, which will allow our panelists to answer questions in real time throughout the presentation, or by sending them as a message inside the chat room to all panelists or everyone in the meeting, and our team will compile them for discussion. Over the past few weeks, I've had the pleasure of getting to know our panelists a little bit better while developing this session, and I have to say I couldn't be more excited for today's presentation. The expertise and experience they are each bringing to this panel is unmatched and well-deserving for the second edition of our Policy Council Conversation series, featuring insights and invaluable content directly from members of NCIA's Policy Council, the preeminent think tank for the cannabis industry. A huge thank you to all our attendees and a special shout out to the NCIA members for joining us this morning. And with that, please enjoy today's session entitled Policy Council Conversations, Protecting Your Cannabis Brand, being moderated by Karen Bernstein, managing partner at longtime NCIA supporter Bernstein IP. Take it away, Karen.
Hi, everybody. Thanks for joining the webinar today. I hope you're staying safe and well, and you find this session to be interesting and perhaps help you in your own business. I want to introduce you to some really great people. Joining us today, we have Max Schnurrenberger, who is the Chief of Staff and Vice President of Operations for Go Fire. Max is a process-oriented and technology-focused entrepreneur in the health and wellness space. He's responsible for the day-to-day leadership and management operations of Go Fire, a life sciences and technology company. I also would like you to meet Chris Passarelli. Chris is a partner at the intellectual property firm of Dickinson, Peatman and Fogarty. He practices trademark, trade secret, copyright, and business law in a range of industries from internet and high technology to agribusiness, food, wine, hospitality, arts, and entertainment. He does a lot of things, and he's rooted in the wine regions of Napa and Sonoma. His firm provides full-service legal representations to clients throughout California, the U.S., and abroad. His major practice areas include alcohol, beverage law, business and corporate dealings, land use matters, labor and employment, civil litigation, intellectual property, which we call IP, geographical indications, real property transactions, water law, as well as agricultural law. And without further ado, we also have Ross Gordon. He's the policy director at the Humboldt County Growers Alliance. And Ross is known as HCGA. It's a trade association comprised of over 200 independent cannabis businesses in Humboldt County, California. And prior to coming on board with HCGA, Ross worked as a policy staff for California Growers Association, a statewide trade association, primarily representing the interests of small, independent, and legacy cannabis farmers in rural California regions, including Humboldt County, Mendocino, and Sonoma, Nevada counties. So thank you for joining us, gentlemen. Let's start this out here. Max works a lot with patents at Go Fire, and perhaps you can explain to the audience a little bit what patents are, and we can go from there.
Excellent. Thank you, Karen. As Karen mentioned, my name is Max Schnurrenberger. I'm really glad to be speaking to you here today. Just as a brief introduction, patent protection is a powerful tool to maintain strategic control over a specific process, machine, composition of matter, design, etc. A patent for an invention is a grant of property right to the inventor issued by the United States Patent and Trademark Office. Generally, the term for a new patent is 20 years from the date on which the application for the patent was filed, or 21 years from a provisional application. Functionally, a patent is the right to exclude others from making, using, offering for sale, selling, or importing the invention into the United States.
That's right. And so with patents, a cannabis brand could have, for example, a patent on a child-resistant packaging, or they might have a patent on a special kind of pipe that might do something interesting, like a bong. You can also get what they call a design patent, which is an actual design. For example, in the non-cannabis arena, the Apple iPhone, the way that it looks on the interface is a design patent. So perhaps you have packaging for some reason. I used to be the head of packaging, or the chair of packaging, the labeling at the NCIA. There are design patents for packaging. So it's an interesting way to protect your property. Patents are good for 20 years, design patents less. Design patents actually are easier to get, whereas a regular utility patent that has some functionality can take 18 months till you even get started. So something to bear in mind when you're considering patenting an item. So Max, how do you patent a new product or idea? I know that's kind of a general question, but you could give us
Absolutely.
a basic understanding.
And thank you for the extra background on design patents, which are vitally important as well.
Yeah.
Yeah, we are in the ancillary space, so I do feel comfortable talking about this. I'd say the first step is really understanding your invention and what its distinct features are. What are you actually trying to protect? Otherwise, you can end up with claims that are not covering the aspect of the invention that's really important to you. I know in my experience, we were trying so hard to cover other features of this complex device and ecosystem that we didn't double down and spend enough time drilling in on one feature and adding more verbiage around it. And it really, an examination came down to one word. So understanding what's important to you and what provides an attorney, obviously very helpful here, what is kind of the crux of the invention and what you need to protect to block others from using it. The second part is engaging with an attorney or agent. I can't stress how important this is. I've had really good ones and really bad ones. The biggest thing I'd say is being able to communicate effectively with them. At its most basic level, it's going to cost you more money if it takes longer to explain things to them. It really helps if they're interested in the technology, because then they can be more forward thinking and they can get the creative juices flowing and think about ways that you might miss for protecting it. And also just, it'll be a stronger application if they have a good understanding of the product or the invention and they can design around that.
So wouldn't you agree, Max? I'm sorry.
No.
Wouldn't you agree, and I think you kind of touched upon this, that you really have to, the more that you can tell the patent attorney what your invention is, the easier it is for the patent attorney in order to understand what you're doing. In other words, it's like writing a book or a play. If you can explain your invention in like one paragraph with 4 or 5 sentences, that's going to help the patent attorney. Don't you agree?
Absolutely. And kind of in that same vein, making sure that you're an involved partner in the drafting process and all the way through filing is crucially important or vitally important because you know the technology better than them. They're going to add the legalese around it and they're going to write it in ways that are going to protect you. But if something doesn't make sense to you, you need to ask them, and then they should come up with a succinct answer about why they're writing it that way, why it's aligned with the way you've explained it to them, and why it's protecting you that and the way it's written.
Max, I'm sorry to interrupt, but
no.
Like me, you're not a patent attorney. I'm an IP attorney, but I don't have a science background. My father was a patent attorney. I grew up around patent attorneys. I did patent litigation early in my lifetime. So it's not like you have to have a intensely technical background to understand patents. If you're an inventor and you know your thing, you shouldn't feel discouraged to try and innovate and work and possibly see whether you have a patent or perhaps a trade secret, which is for another discussion, possibly with Chris.
Absolutely not. There's a ton that you can do in those early stages. I am actually not even inventing this stuff. We have an incredible engineering team. I act as a conduit. I explain what we're doing to the engineers. And like you said, I am not an attorney. I've been able to build this knowledge just from a lot of reading with them and learning from them every day. And now I'm able to save us some dollars by helping in the drafting of our abstracts. And it serves as a really good way of the attorney taking my writing, which is, not as technical, and then just rewriting it basically. It's just saving them a step and making sure that we're super clear on what we're trying to cover. And that's the last thing I'd add on the attorney side, is be incredibly clear about billing and how much things are going to cost, because it gets very expensive very quickly and you need to support that burn. So you need to be eyes wide open.
Yeah, definitely. How do you build your portfolio with your patents to successfully enforce the patent from, say, counterfeiters, Chinese knockoffs, competitors?
I'll touch on that. I think I'll just summarize through a couple more things.
Sure.
Provisional application is incredibly important. It protects your invention for 12 months before you file the full utility. The way I think about it, a provisional is like a pyramid. It's the base, it's the broadest. As you go further along in the process to a full utility and through examination, you can't add new material because it's getting narrower.
Right.
So
for the audience, to explain a provisional patent is that you say that you've come down to what you think is protectable as a patent. It's an invention, and you want to be able to get investors in your to look at what you've got. But if you disclose it publicly to anyone within a year, that falls into the public domain. So what a lot of entrepreneurs will do is they'll file what they call a provisional patent application. What that does is lock in the date that you first disclosed it. It's recorded, and it's cheaper than filing for a full patent application. It doesn't really get examined, but the idea is to build protections around that so that you can try and shop around to try and get investors in your company. That's one reason people do it.
And the last note I'd say is it's got to be strong, because if you have a really bad provisional, it can actually be a detriment to you. It can prove that it was indeed not an invention, or that the invention hadn't ripened past the idea stage.
Yeah, and you also want to consider whether perhaps signing an NDA is helpful anyway, but a lot of investors won't do it. So that's why
it's a really delicate dance when you're trying to fundraise and develop a new product at the same time. Absolutely. Yeah. The last step is just filing that the application. Karen, I'll circle back to your second question. This is something that I'm excited to talk about. Let me
just repeat the question, Max, again, so the audience remembers. I asked him whether how he builds the GoFire portfolio to successfully enforce their patents from Chinese knockoffs. We all know that there are tons of vapes out there, for example, and say you've got a design patent on a vape, the way that it's designed, and you enter a contract with a Chinese manufacturer. This is an old story in many different industries where somehow that product goes out the back door, and it can be really detrimental, especially, as you know, we had a problem with the vape crisis several months ago. It seems like not even yesterday, it seems like it's 5 years ago. So Max, give us an idea of what you guys are doing.
Yeah, I think first of all, and I think this goes even domestic as well, is relationships are one of the most important things with your manufacturer, your distributor, your agent in China, if that's the case. It's got to be a mutual relationship, that you can't be taking advantage of them. Otherwise, they have no incentive for not doing something like that. And also spending the time to make those personal connections, traveling, etc., instead of a Zoom, vitally important. And then a simple supply chain. Other than that, though, one very powerful tool, especially with respect to China, is a design patent. If it's filed in China, you can actually have intervention facilitated through the Chinese consulate for takedown requests through Amazon and Alibaba. So that's something I actually learned relatively recently from an agent friend of mine. So critically important tool. Again,
that's a PCT application. If you're able to get a full patent application in the US, you get 18 months, I believe, to designate various countries, and China is one of them, so that the Chinese government, provided you get the patent issued, will recognize your patent, although it takes years to get that patent.
And the design patent, I believe, is quicker. But with respect to the patent cooperation treaty, just to touch on that briefly, as she mentioned, you have some extra time to figure out what countries you want to elect to. Where should you file, aside from China and other places? That's a big question that I struggled over, because there's a lot of countries, right? And you want to sell in all of them.
And it's not cheap, and you have to get translations a lot of the times.
It is enormously expensive. So what I kind of offer as advice is think about, where do you want to sell, manufacture, and distribute? Look at those, create a list of countries, rate them, and then forecast the pricing on the filing, the translation costs, the maintenance costs, and see if you can support that, and then cut away from there. A couple other things to keep in mind is, like, if they make $4,000 annually in that country, they're probably not going to buy a $300 product.
Yeah.
So it may not make sense. Or if it's a medical, recreational, adult use country, or not, that may inform a decision. But it's kind of like gambling with the rate these new countries are coming online and new markets are opening.
Yeah, I hear you. What do you think are the biggest challenges that green entrepreneurs, I like that term, green entrepreneur.
I stole it from someone.
I like it. Green, what do you think the biggest challenges are for green entrepreneurs when it comes to patents?
That's a great question. I think the elephant in the room is the Controlled Substance Act. If you were to try to enforce a federal patent, all patents are under the jurisdiction of the federal court system, and you tried to bring in a federally illicit substance in as evidence, it's almost a non-starter. But Karen actually brought up a really good point, which is that there was a Colorado lawsuit filed in 2018, which was United Cannabis versus Pure Hemp. This may change this soon. It's marked as the first cannabis patent infringement case, where United Cannabis Corp is filing suit over infringement of cannabis extracts and methods of preparing and using the same. To much surprise, on May 22nd, 2019, federal judge Nina Y. Wang allowed the patent lawsuit to move forward after rejecting Pure Hemp's explanation of how United Cannabis's patent was invalid. We're all watching to see what's going to happen next with this. It could greatly change. It could change the landscape completely in terms of enforcement and moving forward. I hope I covered that one enough. I think there's one other point that I'd say, which is litigation, especially with respect to some of these bigger multi-state operators, Canadian LPs. As alcohol and tobacco companies are entering the space, they have much deeper pockets, and there's some mechanisms through the USPTO's PTAB that can restrict the amount of I can't think of the word to use, but
let me just tell the audience what PTAB is. Hold on.
Oh, please.
So when you're filing in the patent office, there's other inventors or companies that might want to block your patent. And so it's a kind of the litigation wing of the patent office called the Patent Trademark Appeal Board.
I believe that's correct.
Yeah. And that is an administrative court. It's not like real court. There's no money damages involved, but you could block a patent. So Max was talking about PTAB. That's what
and the key thing there is they don't have as many mechanisms for dragging the case out and just killing you in attorney's fees. But then obviously you can bring a suit to federal court as well, and being eyes wide open on
the PTAB action. It usually suspends the PTAB action when you go to federal court.
Yep. But just being eyes wide open that these people have much bigger pockets than I do, and we've been raising money for a while. And that a lot of cannabis entrepreneurs, I would imagine, just being totally eyes wide open on the prospect of litigation and how much it would cost, because you could have a totally winning case that you could never win. My
patent law professor always said that patent litigation is the sport of kings. It's so expensive and takes forever. And, you're talking about the Controlled Substances Act. The interesting thing is that patents, you can get a patent, and there's no problem because the Controlled Substances Act is, even though it's a federal statute, when it comes to patents, they don't care. I mean, there've been illegal patents issued over the years. except for bomb making and things like that, the patent office will allow you to get a cannabis patent. Whether you can enforce it in federal court is a question, which is what brings up the UCAN case. But unlike patents, we're going to move over to Chris, and Chris is going to talk more about trademarks, which unfortunately are subject to the Controlled Substances Act by virtue of the fact that trademarks are generally on a federal level. When you're going from one state to another, there's federal interstate commerce, and that's when Congress stepped in, and any laws that Congress makes, including the Controlled Substances Act, subject trademarks that touch the plant as opposed to ancillaries. So Chris and I we're gonna move over and talk a little bit more about trademarks and some other issues involving trademark related themes. So Chris, just briefly explain to the audience what a trademark is so we can distinguish that from a patent.
Trademarks are a really interesting animal, Karen, as you know. It can, anything that indicates source to a consumer could be considered a trademark. So we often traditionally consider things like names and logos and slogans to be trademarks, but trademarks take other forms. 3D product and packaging configurations known as trade dress are a form of trademarks. And the oft forgotten service mark, which is treated equivalently to a trademark, which technically applies to goods. So you could have trademark protection for things like color combinations, smells, sequences of notes. And so, when we talk about trademark law, we are really talking about a broad array of creative or assets, naming assets, and things that create an association with a given source. That goes back to consumer protection as well as the property rights underpinned by the trademark law under the Lanham Act and the individual state trademark acts.
Right, and remember, consumer confusion is really the hallmark of trademark law, which is for people not to be confused, to be able to distinguish your goods or services from others, right?
That's it. It goes back to the old common law passing off. One seller passing off their goods as those of another, or reverse passing off. So, that's where it all began. And so, when we look at trademark law through that consumer protection lens, I think it's more friendly to the cannabis operator ultimately, which gives me some heart and some comfort and optimism for the future, looking at the policy underpinnings of trademark law.
Yeah. What forms of registered protection are available, though, for cannabis at the federal level?
Well, as we spoke about the CSA, the Controlled Substances Act, really kind of acting as the wall, if you will, for federal protection traditionally, like it is for most other trademarks that are non-cannabis. Unfortunately, due to the CSA's prohibitions on cannabis, the manufacture, sale, importation, transportation, and interstate commerce, it really it runs afoul of the Lanham Act, which requires use in interstate commerce, lawful use in interstate commerce. And so
Lanham Act is the federal statute that governs trademarks, just saying.
Yeah, also known as the Trademark Act. And so because the Trademark Act requires a lawful use in interstate commerce, this really runs afoul of what's going on at the state level with many of the cannabis operators, the state laws. And so there have been challenges, shall we say, with registering.
What do you advise?
Excuse me?
What do you advise your cannabis clients if they're a plant touching business? What can they do to perhaps get federal trademark rights in, say, other areas that might help to protect them? What do you say about that?
Well, there's always state registration, and at the federal level, I think you want to try to make an effort to be, a pioneer in terms of establishing some sort of protection for your marks. And what we've enjoyed some success with the registration of ancillary goods and services, and there have been certain classes, international classes, because trademarks and service marks, when registered, fall into this categorization scheme called the NICE classification. And so we look at the, classes outside of cannabis per se, which would be, of course, prohibited for registration.
So, for example, if you own a dispensary and you also give yoga classes, you might be able to get a federal trademark registration for educational services or with yoga, right? I mean, that's one way of doing it.
Thank you. That's a great illustration. In fact, most of us in the technology age provide some sort of education or information, via often online. And so when we try to protect ancillary goods and services, often they'll fall under these this sort of rubric, whereby someone's providing product information, education, consumer information, and that would be mostly things that would fall under, I think, class 35. But we've also, been successful in class 41, which kind of handles things like events, entertainment, and then things you might not normally associate with events and entertainment, like club membership services. It seems to be very important in this area.
Right. We've also been able to get people for providing an informational website, because you have a First Amendment right to speak. They can't deny you a trademark based on the fact that you might be discussing cannabis. I mean, think about High Times and all the other publications that are out there. They've got tons of trademarks. And so as long as you're not directly touching the plant and there's no confusion between your mark and an existing pending application or registration, you may be able to get federal trademark rights on that.
That's right.
And the idea of getting those federal trademark rights is let's just say that, cannabis is legalized finally on a federal level. Where does that go in terms of enforcement? Because remember, we were talking earlier about how it's difficult to enforce patent rights. It might be difficult to enforce trademark rights on some state law cannabis trademark. What if you do have yoga and a trademark registration for yoga and they lift the prohibition? How is that going to help the client down the road in terms of enforcement?
Well, you've established prior use evidentiarily. I can't understate the benefits attendant to federal registration. They really save so much money on the back end for really a nominal investment on the front end, because you get these legal presumptions of ownership, validity, that when you step into the courtroom, we're going to save you tens of thousands of dollars, and otherwise you would have to produce evidence showing sales in every discrete geographic market.
Special damages because you have federal trademark rights.
And notice to others. So, it can't be understated. It's interesting you made a reference to the publication High Times. A lot of the law that we look to that for the answer to the issue of whether goods and services are related, and whether, registration early on for those ancillary goods and services can help the cannabis operator down the road, kind of relate to this idea that, that started with publications. There was actually a case called Triangle Publishing that stopped a furniture manufacturer using a similar mark as a magazine publisher, because the furniture type items were advertised in the magazine. So going back to your yoga cannabis paradigm.
Yeah, and so I think in a nutshell, what we're trying to say here is that if you have a federal trademark for, say, yoga or wellness classes, and someone's operating perhaps in another state, you might be able to say, well, what you're doing is related to what we have federal trademark registration rights in, and be able to stop them. Although I do say that it's a weak argument, and we need to have prohibition listed, which is why my firm's an NCIA member. So let's take a look at some other things that I'd like to discuss. We talked about other forms of registered protection. What happens if a cannabis business does nothing to register their mark? Do they still have trademark rights?
Arguably they do, depending on how the state might recognize it. So in California, where I'm at right now, arguably you would have common law trademark rights, but there's concern. So, anybody has a trademark and has trademark or service mark rights from the time they begin using a certain indicator, a mark, in conjunction with their goods or services. And you would have rights. But, I'm looking at, for example, this Kiva case, the recent ruling that came down, where we had a prior user of Kiva for cannabis products that was, a defendant in a case brought by a health food company. And they weren't able to rely on their prior common law use as an affirmative defense to infringement, where it was found that the federal law definitely preempted state law, did not provide a defense to the otherwise, arguably innocent cannabis actor in that case. So it begins with the proposition that this is an uphill battle, I think, as you're alluding, and there for the short and medium term will be challenges. But again, I'm optimistic about the trends, what we've seen with like hemp and CBD at the federal level, although maybe not fully realized, but there's a push there.
Yeah, I think that we do have a question from the audience, and the question was, in consideration of the Controlled Substances Act, what cannabis classification should a cannabis brand file their trademarks under? I think we already covered classes 35 and 41, but there's no reason you can't also register clothing, provided you're doing it right. Hats, caps, merchandise in general. Clothing fits under 25, and some merchandise like posters could be 16. But for example, for trademark, this is coming from, gosh, I'm trying to see who this is from. This is from Jeff Kang. He asked, for example, for trademarking a unique flavor name in connection with THC distillates, as opposed to just the brand trademark of the company. I think that what he's trying to understand is, could you trademark a unique flavor name in connection with a THC distillate?
Definitely at the state level. You can't federally register for a product that would be prohibited under the CSA. So at this point, probably not per se cannabis, which would fall, under probably 30 or 29 for the flowers or for the byproducts thereof. So you'd have to look for some other aspect to it. Some enterprising cannabis operators I've noticed would, kind of expand that branding maybe so that it would cover other things that we're talking about. Yeah. The marketing and promotion, the product information, the education that is attendant to the product, and right. So you might be able to achieve some registered protection that way. Although I caution you because, there's requests for information in the application process at the USPTO, which could really undermine everything going forward for you. So you really want to engage Trademark Counsel to interface with the Patent Trademark Office, don't you think?
Tell me, Chris, we only have a couple more minutes left for your segment. Can you explain to the audience some other forms of IP protection that people can get besides patents and trademarks?
Yeah, I mean, like in this landscape, you're sort of left to cobble together protection in some maybe often overlooked ways. So, things that have worked for some operators, it would be like domain registrations from the outset. As soon as and you're in the process clearing your trademark or service mark, you should also be thinking about picking up all those commercially valuable URL strings that
I always say to my clients, before they get a trademark search, Google search as much as you can, the proposed name. Can you get the matching domain name? If you
and in fact, you should check for the domain with your credit card in hand, with some intent to at least provisionally commit to it, because if you search for the domain, often it'll get nabbed by a registrar, and then you'll have to buy it at a greater price. The other interesting thing that we've done in California is the availability of a ranch, villa, estate, farm name registration. So that's a $10 event that you send to the Secretary of State, and it is equivalent to a state trademark registration.
Wow, that's really cool to know.
So if you're a permitted operator and you don't mind disclosing your address, that's another available channel for registration.
Yeah. Well, we don't have a lot of time to talk about copyright and trade dress, but I thought maybe because we're going to get into discussing appellations, you could just explain to the audience briefly what a collective and cooperative trademark is. And then we're going to talk about appellations, which are slightly different than trademarks.
Well, yeah, collective mark is yet another variety of trademark or service mark where it's shared, where you have a group of producers that have a collective identity, if you will. And I think of like the California raisin. I'm not sure how many folks are familiar
Or
with
the
it.
orange producers, the orange juice guys, gals.
That's right. So no one producer would own that trademark, and they act kind of collectively, and yet they're able to efficiently exercise efficiencies and enforcement, and of course the goodwill that inures from having that across the industry in that sense. And that's kind
the downside is that you can't, as a cannabis company, exclusively own the mark, but you can collectively with other, say, cannabis farmers.
And there are parallels with this other notion of geographic indications and appellations. They're very closely related, in fact, and both are close cousins to trademark law.
That's a really high level discussion, which is that geographic, saying California raisins, can you really trademark? It's kind of generic and also geographic, but as a collective mark, as farmers, you might be able to get it, but that's for another day. Thanks a lot, Chris. We're going to move on with Ross now. Ross, you're involved with the Humboldt Growers Association, if I'm saying that right, I forgive me. One of the things that I find fascinating, this whole thing that's going on in California, there's some laws that have been passed by the state of California, and there's kind of a comment period right now. Can you explain to the audience briefly, just as an introduction, what appellations are?
Thanks, Karen. Good morning, everyone. My name is Ross Gordon. I'm Policy Director with Humboldt County Growers Alliance.
Humboldt County Growers Alliance, thank you.
County. It's hard. I got it wrong for a while. I was saying association instead of alliance, even after I started working. So it's hard to keep it all in mind. So I like to kind of start a lot of times from the political and policy background, because I think it helps underline some of the reasons why we have an appellations program and what the intent of that program is. So one thing that I think is unique about cannabis legalization, particularly in California, but also in other states, is that it really legalized an existing industry, that it existed in this part, the far northern part of the state, for decades. People growing cannabis on small farms, on very small levels on their own land. And so there was sort of this deep knowledge and this deep culture and this deep tradition of cannabis cultivation in this part of the state. That had developed a reputation. I mean, people all over the country, all over the world, know about the Emerald Triangle, know about Humboldt County, know about Mendocino County. But that sort of collective, let's say, intellectual property wasn't owned by any specific farmer or specific person. That's really a form of IP and reputation that existed collectively among many farmers in the region. And today in the Emerald Triangle, we have 1,500 independent cannabis farms with an average size of about 1/3 of an acre. So these continue to be small farms that may not have the ability to do marketing of a particular brand, but collectively have this really strong reputation. So in response to that, when California finally got around to sort of regulating and formalizing cannabis regulations in 2015, after 20 years of basically a Wild West legal but unregulated medical cannabis market, one of the first things they did as part of that system was provide specific protections for that form of collective intellectual property. And that took two different forms. One of those forms was what is called county of origin. So the idea that you cannot use the name of a California county, like Humboldt County, like Mendocino County, unless 100% of the cannabis in that product is produced in the stated county. And that went into effect immediately in 2015, and that's already something which is a legal tool which has been used to prevent sort of fraudulent advertising and protect those regions. The second program that California put into state law was called an appellations program. And that's appellations, APPELLATIONS, not appellations like the mountains. And the idea of an appellations program is similar to the way that wine is protected. Some of the most famous appellations are Bordeaux and Champagne in France. In the United States, Napa Valley, Sonoma County, and their sub-appellations are very well known. It's a way of protecting the geographic location in which an agricultural product is produced. So Champagne, must be produced in the Champagne region of France, and it must be produced according to certain methods which are agreed upon by those winemakers. And it's supposed to have a unique quality which comes from that set of protections. And similarly, the idea with cannabis appellations is that regionally, not even within Humboldt County is sort of a political boundary, but within subregions within Humboldt County, within different microclimates that might have different temperatures, different elevations. There are specific qualities of the cannabis produced in those areas, as well as specific qualities and cultures and sets of agricultural practices which align with that. And that's a form of regional and collective IP that deserves independent protection.
So basically what you're saying is that nobody can call themselves Humboldt grown if they're selling cannabis, unless it's really coming from Humboldt. Very similar to champagne, you can only call it sparkling wine. I'm wondering what down the road people are going to do, and the alternative to similar in the cannabis space, what they've done differentiating between sparkling wine and champagne. Any ideas what somebody might want to call their cannabis, particularly because there's something known as terroir. It's spelled T-E-R-R-I-O-R. And as I understand it, it has to do with the soil. The fact that many are pushing, and I'm not taking a position. I do have a position, but I'm not going to say that if the cannabis has to be sun grown and grown in the earth as opposed to in a greenhouse, right? So what happens if someone is growing cannabis in Humboldt or Mendocino and they're not doing it in the earth, and it becomes law in California that it must be in the earth, what they're going to call it? I'm just speculating. That'd be a fun question. You have any ideas?
Yeah, absolutely. I think it's such a critical and important question. I guess speaking to the terroir component first. So terroir is a French word, as you would think. It sounds like a French word, that encompasses this idea of what appellations are supposed to denote, which is the specific relationship between the land, the soil, as you mentioned, Karen, the climate, the elevation, everything that goes into it, both in terms of those natural factors and also the human factors. Who are the people who live on the land? What are their cultural practices? What are their agricultural practices? And the idea is when you put all these things together, you get something which is unique and specific to a region and land, which cannot be replicated somewhere else. And that's really the premise of.
Do you think, and this is where trademark comes in, Chris, in terms of the hallmark of trying to prevent confusion? What if I called my cannabis that was grown indoors in Humboldt, whatever the brand name, and then in small print I write from Humboldt County? Would I get in trouble for that? Do you think if that's what the appellation law is about? Isn't there a way around this that?
And I think this is an important point, and I think that's a great question to raise. So we have sort of a two-tiered system, and I think this is exactly why we have a two-tiered system. That there's, on one hand, there's a county of origin program, which protects the name of a county, like Humboldt County. And on the other hand, you have an appellation program, which is really about the land and the soil and the natural environment. So any cannabis that's produced in Humboldt County, whether it's indoor, whether it's outdoor, whatever the case might be, however it's produced, as long as it's produced in Humboldt County, it can use the name Humboldt County. And if it's not produced in Humboldt County, then it cannot use that name. So we really see, and I think the intent of the program is, the county of origin program is a maximally inclusive program. Anything produced in that area gets to use the name. The idea of an appellation is a different idea that really deals with, as you mentioned, the question of terroir, the question of what is the impact of the natural environment on what's being grown. And I think indoor is a great example because obviously indoor controls every aspect of the process. So Humboldt County indoor, there could be a certain reputation associated with that, and you might want to protect that reputation. Maybe people like the idea of Humboldt County indoor, as they should, because it's fired. But that theoretically, the growing conditions for that could be replicated in Portland, in Chicago, in Los Angeles. And so that's why there's kind of this division between just that indication of source, Humboldt County, and the idea of terroir and appellations. And one maybe last thing to say about terroir and appellations is I think there's really a lot of precedent on this because appellations aren't a new idea. Appellations exist in wine and in other industries, and in wine, as far as I know, and Chris, I know you work sounds like more closely with the alcohol industry than maybe we do, but as far as I know, that's all planted in the ground, and the soil is a really critical part of how the wine industry establishes that terroir and establishes the uniqueness and typicity their wine. So understanding there's a lot of different cultivation methods for cannabis, the idea of terroir and the idea of soil, I think, is a really central question when talking about that form of protection.
Oh yeah, I mean, there's so much crossover between trademarks and appellations, but yet the basis of it are two separate things. One is to prevent consumer confusion, which is trademarks, and appellations are really to preserve the origin of the product. Let me ask you one final, well, let's just go about here. Let's see, there's something about, you talked about the California's appellation program. It's finally scheduled to be implemented January 1st, 2020. What's going on with the program? What's the status, and how do you anticipate it's going to be rolled out?
Yeah, so the deadline for implementation right now, and this might change because of everything that's going on in the world, is January 1st, 2021. So it's the deadline for implementation is in 6 months. So right now we're going through the regulatory process where the California Department of Food and Agriculture, which is the department that regulates and enforces cannabis cultivation as well as appellations, they've released their proposed regulations for appellations, and those are currently undergoing a public comment process. And actually the deadline for submission of public comment is today.
Wow.
And after I get off this call, I'll be jumping on the Zoom call to comment to the agency. So
the International Cannabis Bar Association, of which I'm a board of director member, is going to be submitting their comments today, I believe. Right, Shay? I think so. Shay's also a board member. So, but yeah, we're working with that. Go on. I'm sorry. That was just a shameless plug.
No, I appreciate, and I'm aware of those comments, and I think it's really awesome that NCBA is bringing that technical expertise, because it's such, I mean, it gets into a lot of detail, as you know. So I really appreciate that. Yeah, so we're in this regulatory process. The deadline for comment submission is today. I think CDFA will really have to take their times to consider those comments. We're going to have another couple months of them reviewing and digesting those comments, and potentially, if they make significant changes, which I think they should for a program of this magnitude with this complexity, we'll have another comment period coming later this year. And there'll be an opportunity to finalize those regulations. And then, unless things change, which they might, we will kick off on January 1st, 2021.
Well, that sounds great. We've got 5 minutes left with you, Ross. Can you give us your thoughts beyond California, and how do you see appellations playing out in other states and at the federal level?
Yeah, so I think it's a really important question. You know, California has this whole program, and at this point has invested a lot of resources into creating this form of protection. But ultimately, the program doesn't really make a whole lot of sense if it's just housed in California. You know, the idea is that both appellations and county of origin, those need to be protected across the country and ultimately across the world. And that requires recognition in other states and potentially in international treaties ultimately as well. I think there's kind of two levels of this. One is what's going to happen in different states. And I know that there's interest in other states for having some sort of appellations or county of origin program. As far as I know, and I'm pretty sure about this, no other state has actually done that, but there's definitely interest. I think,
I can tell you that here in New York, I have a client of mine who's a hemp farmer. They're possibly looking at appellation rights for hemp here in New York State. So I think that that's a concept that is not unknown to farmers in the cannabis and hemp space.
Yeah, that's awesome. I hadn't heard about that in New York until you mentioned it, but that totally makes sense. And we've talked with farmers from Oregon. I think Oregon has a lot of the same history as California in terms of a lot of legacy cultivation farmers, communities based on that, who have a collective reputation that they'd like to protect, places like the Applegate Valley. I think the most important thing, I think obviously it's essential that other states start to consider it and enact this form of intellectual property protection. I think the essential thing is to do it in a uniform way, because I think if you have many different appellations programs, each with different standards, that becomes very confusing to consumers. That makes it very difficult to communicate what are we talking about when we talk about appellations. How does that designation have meaning or integrity to a consumer? And
Well, what
So
do they do in the wine industry? Because here in New York, we have the Finger Lakes, and I'm not going to tell you how good I think the wine is, but there's the Finger Lake region. Chris, do you have any experience in the Appalachians and other states other than California in the wine
Unfortunately,
industry?
no. We've been working as NCIA as to see the evolving policy, that there are competing policies that are developing.
I don't know how on earth you're going to have a uniform appellation. I mean, there's certainly, you could do model form. I mean, that's what NCIA has done before for packaging and labeling standards. So I don't see why they couldn't maybe try to come out with something for appellations that other states can follow.
So ultimately, I think the hope would be that the federal government is the regulator, and the federal government's the regulator for ultimately for wine appellations administered under the TTB, which is, I always forget, but that Tobacco Tax and Trade Bureau. I think.
Tax and the TTB. Yeah, they also vet labeling.
That's right.
TTB. That I know just from being around. Finally, well, to the other regions. I don't know too much about other than California, and Humboldt is the most famous in the United States. I don't know of any other region in the United States that is well known for cannabis. So it would totally make sense to me that California would lead the way in that regard. But I think that we're pretty much up for time right now, and want to thank you very much. We have a couple of questions from people. If the administrator could just give me a chance, I have some questions in the chat. I don't have that Google Drive. Brian, do we have any questions from people? Because I can't, for some reason. Oh, here we go, I guess. Oh, there we go. Okay. A couple of people had questions. Ed Vickland, I'm not familiar with the company he's with, but he says, unfortunately, I had to leave the meeting, and he'd like to ask the panel what other methods he could use to protect his product. He says he has a trademark and copyright on his logo, and he has a hashtag known as stash tag brand, but would like to know if possibly a design patent or other method could protect the stash tag product. I'm trying to understand his question. I think he's saying, look, I have a trademark and copyrights on my logo. His brand is known as stash tag. And he wants to know if there's any possibility. Didn't we talk about design patents and product labeling, packaging?
Karen, we also talked about trade dress, packaging, trade dress, product, trade dress, copyright, if it's not functional. So I think those are the things he's alluding to without getting into the specifics of his particular product.
Yeah, I mean, trade dress is another day, unless you want to tackle it in 2 seconds.
Oh, yeah. So, I could. Packaging trade dress is a no-brainer. It's just like a trademark application. Product trade dress, you got to prove distinctiveness, because the trademark office doesn't just want you to be able to trademark product configurations. And we're talking about 3D product shapes.
It's not easy to get. That's the reality, is that you have to put up a lot of proofs. You work with a trademark professional who can help you with that to determine whether or not you have a protectable trade dress to begin with. What's trade dress? Well, it kind of sounds like it is. It's like a dressing for your product. So there's some good examples of trade dress. I'm having a mental block. Chris, you have any idea?
The brown gestalt of the UPS truck plus the uniform.
Yeah. You even have trade dress in your dispensary. Like I know years ago, early in my career, the firm I was working for, we represented Sephora. So when you walk into a Sephora, or even IKEA for that matter, you know the way it's laid out. It's wild, but you can do it that way. Not to mention the Mexican restaurant in 2 pesos, but.
So Karen, there was a time when if a product, I had a client with a product that had like non-functional features, and you'd start looking at things like trade dress applications for registration, design patents covering the ornamental feature, and maybe copyright too, if it's non-functional. And you get into the spats with the copyright or the trademark office about whether something's functional.
It's hard. And then when we say non-functional, we mean that they're decorative in such a way that they're not part of the actual invention or
and not encroaching into patent law.
Yes,
or the domain.
it's an interesting, and yes, Carrie Rodstock, you do need to trademark your logo. But anyway, let's see. I would like to go back. Jeff Kang had another question again. Okay, we talked about distillates, right? And then I thought Jeff had said something about, oh, what about trademarking essential oil? Well, the problem, Jeff, is that the minute that you go to show proof of your trademark to get the registration, you're going to see right away that you have THC in your product. And even they will go so far as to actually go on your website and look. And they may have what Chris and I discussed was called a request for information. They're going to ask you for marketing information. So good try, but I don't think that's going to work out.
One thing you could do though is set up like a lifestyle brand whereby it was identical to the distillate brand, and then you kind of have a front-facing public view for what you might want to seek registration for, whether it's product information, education, providing, you know, information via a website, and then have a few clicks back, you've got your distillate.
Yeah, that's the right thing to say. Don't think that just because you can create a product that doesn't have THC and have it in states, for example, you're selling it in that don't have medical, or even if you are selling a non-THC product, that you can lie to the federal government and say that you're not violating, you're using the trademark lawfully. Although a lot of brands do it, I'm very concerned that down the road they're going to lose their trademarks because competitors are going to out them. And you have to show actual knowledge of fraud on the trademark office. That isn't actual knowledge, I don't know. At the time that you filed the application, if you're selling things with THC in them and you're telling them that you're not, even though you're selling maybe in states without the product, you're still using the same brand that contains the THC. It's a big no-no. Well,
this is sort of the parallel to the DUI attorney saying don't talk to the police without the attorney present, is don't talk to the patent trademark office without your trademark attorney.
Correct. So I think we're up on time, barring any other questions. I think we're about to actually, we're right on time. So thank you so much for joining us, and we hope to see you again in the future. Don't hesitate to reach out to any of us for questions if you'd like, and you can see all of our contact information on the screen. I hope you have a great day, and I hope you stay safe and well out there in these crazy times. Thanks a lot.
Wow, thank you so much, Karen. Let's give all these panelists a virtual round of applause by posting a quick message in the chat room. Let them know what piece of information was the most valuable for you that you're going to be taking away from this presentation. And as Karen mentioned, please do not hesitate to reach out to any of the additional panelists. All of you all will receive a PDF version of this presentation immediately upon the conclusion. So stay on the lookout to the email address which you used to register, and make sure to fill out our attendee survey to let us know what you thought, and you'll be sent that PDF immediately upon completing that survey. Additionally, you all will be the first to be provided access to a video recording of this session as well. So stay on the lookout to your email address which you used to register, and that will be sent along with the completion of the attendee survey within the next 72 hours. We do want to conclude the presentation with just a few short announcements about our upcoming activities here at NCIA, and give you a little teaser for the additional industry essentials educational webinars that are taking place next week. So in case you missed it, we had decided to postpone our upcoming 7th annual Cannabis Business Summit and Expo from June until late September. This decision wasn't made lightly. However, NCIA's primary goal throughout this COVID-19 crisis is protecting the health and safety of our community and the nation at large. You can head to cannabisbusinesssummit.com to sign up to receive all the exciting news we'll be releasing in the coming weeks, including a very special keynote speaker we can't wait to tell you all about, and some very exciting developments for any product brand hoping to make a big splash on the expo floor this year. This will surely be a can't miss event, and one we'll all desperately need on the other end of this crisis. So as soon as you're able to commit to traveling to an in-person trade show later this year, sign up to ensure you are at the epicenter of the cannabis industry this fall. Additionally, we've also postponed our 10th annual Cannabis Industry Lobby Days until this fall as well. However, along with the postponement, we've also made a number of structural changes to the event, which will provide a more all-inclusive experience to the NCIA members, volunteering their valuable time to our efforts. Admission, which is still a nominal fee, will now cover the cost for all attendees to participate in our welcome reception, breakfast training, and our new closing celebration in support of the NCIA PAC. We're hoping to bring together all those who participated in the past, as well as hundreds of newcomers this year to celebrate the 10th anniversary of our organization and the historic progress we've made together this past decade. So mark your calendars. Today is the most impactful 2 days for cannabis industry advocacy. Will now be held from September 15th to September 17th, and you can register today at thecannabisindustry.org/2020 lobby days. Have you or your business felt the pinch from a lack of exposure at in-person events these past few weeks? Well, you're not alone, and NCIA, as always, is here to assist. We're super excited to announce we just released a wealth of digital marketing sponsorship packages across all of our highly trafficked platforms, including the Industry Essentials webinar series. Head to our website to learn more and schedule a meeting with one of our biz dev team to discuss in more detail today. And last but not least, I hope all of you will consider attending the next 2 editions of our ever-expanding Industry Essentials educational webinar series taking place next week. On Monday afternoon, we have the 3rd edition of our NCIA Committee Insights series, showcasing content produced in partnership with one of our 13 member-led committees. This edition will be hosted by our State Regulations Committee and moderated by Maureen McNamara, featuring panelists Greg Huffaker, Michael Cooper, and Margot Bruner, presenting a session entitled Illinois Market, What's Happening and What's Next. Following that, on Wednesday afternoon, we have another edition of our NCIA Committee Insight series, which is being hosted by our Scientific Advisory Committee. The talk will feature Tiffany Coleman, Director of Quality at Copper State Farms Management, presenting a session entitled, Understanding Label Claims, which will explore how label claims came to be, what they look like in sister industries, and why label claims are important for cannabis products. Both of these sessions are free for both NCIA members as well as non-members to attend. So if you haven't already, please head over to NCIA's website to sign up today and invite as many of your colleagues who might be interested as well. And finally, thank you all so much for participating in another NCIA Industry Essentials educational webinar. Our advocacy, educational, and community building work wouldn't be possible without the hard work and dedication of our nearly 2,000 NCIA member businesses. So thank you all for the support of our efforts over the past decade. If you're not already a member of NCIA, please do consider joining by heading to www.thecannabisindustry.org/join after the conclusion of this webinar. And with that, I hope you all have a wonderful week. To give another great virtual round of applause to our panelists, and I look forward to seeing you all again next week for the educational webinars on Monday and Wednesday. Have a great week, everybody.